Chief Justice, Excellencies, ladies and gentlemen, our friends from Singapore and from the United Kingdom and elsewhere, welcome to this, the third lecture series that the DIFC courts have put on this year. Not only are there the people in the room, but this is being beamed live around the world through to the wonders of WebEx technology. So to all of you, those sitting in your office or at home or on your smart device on the tube in a far-flung city, welcome as well. If you have not bought your tickets to the gala dinner on the 9th of October, shame on you. For those there last year, you'll remember the warm applause that Allen & Overy received when it was announced that they were the only law firm not represented. Please don't have your law firm in the same position this year. And if you need tickets, please let us know. Hajja's just here, and she'll very readily sell you a table or two. I'm here to introduce the Chief Justice, not only the Chief Justice of the DIFC courts, but a judge of the Dubai World Tribunal, former president of the Singapore Law Society, former Singapore non-resident ambassador to Switzerland, recognized by Who's Legal as one of the world's leading dispute resolution lawyers, and most recently awarded an honorary doctorate of laws by the University of Sydney in May this year. Chief Justice Michael Wang will be the chairman for this third lecture series of 2014. I'd like to welcome him to the podium.
And welcome to this seminar. The subject of e-discovery has actually been with us since at least 2002. Now, what happened in 2002? A conference took place in Sedona, Arizona, in the USA, to discuss electronic discovery. Ultimately, the Sedona conference developed 14 principles known as the Sedona Principles that memorialize a set of best practices for handling electronic document production. The Sedona Principles have gone into a second edition at least in 2007. I haven't checked whether or not there is a latest edition, but you can easily do so on the web. That, of course, has led to e-discovery rules and practices in the various commercial courts of the world. And today we have assembled some of the speakers from those jurisdictions where that issue is live. And we are very fortunate to have 4 speakers who will be casting light on this subject. I won't say that I'm a Luddite, but I have limited technological knowledge, so I'm very pleased to be able to learn from our speakers here. In the order of their presentation, we have Mr. Robert Kara-Loosley, who is a senior associate with Al-Tamimi from Dubai. He will be followed by Mr. Yong Zi Kin, who is the senior assistant registrar and the CIO of the Supreme Court of Singapore. And then we have Mr. John Laprake, who is from Milnet Limited. And finally, we have Mr. Richard Wilson, QC, who is a barrister from 36 Bedford Row in London. Now, as you can imagine, we will be talking about practices in different countries. The first speaker, Robert, will talk about disclosure procedures at the DIFC courts, which of course will be of immediate interest. Yong Zi Kin will be talking about the experience of Singapore on electronic discovery or disclosure in the Supreme Court of Singapore, and I think you will find that pretty interesting because I have been following developments there as well. John Laprake will talk about the disclosure rules and best practices from the UK point of view, and Richard Wilson will also be talking about the approach of the courts of England and Wales to electronic discovery. I think John Laprake will be addressing the issue from the viewpoint of a commercial company. So we have 4 speakers with different facets of the topic. And I will now, I haven't got the time to go through all of their detailed resumes, but I think they are with you. So please refer to the CVs of the various speakers as they are speaking. And I'll invite Robert Carra loosely to be the first speaker.
Thank you very much. We all only have 10 minutes for our slot, so I'm not going to be able to go through all the detail as I might. I'm a senior associate in the DIFC team at Al Tamimi. I work with the DIFC courts team quite a bit. I appear in the courts probably once or twice a year, and I also work primarily in arbitrations where we have a similar disclosure process. I regularly do the lecture on disclosure as part of the DIFC Courts Academy, which I hope you're all aware of if you haven't been on there already. And we normally get a good hour and a half to talk about disclosure, but I've got 10 minutes. So what I'm going to do is talk about 3 key aspects of DIFC disclosure. And if I have time, I will also discuss 2 more general points on disclosure, which you may find of interest as well. So when we look at the DIFC court rules, the RDC, which I appreciate you don't have in front of you and which I'm not going to read out in any detail, you will find Part 28. Part 28 is called production of documents. It's not called discovery. It's not called disclosure. That's essentially what it is. It's for production of documents. The first key point is about standard document production, which is your normal vanilla flavor document production system at the DIFC courts, which is that when an order for standard document production is made, the parties will disclose to the other party or submit to them copies, documents on which they rely, including public documents and any other documents which you're going to, which you're required to produce as part of any law, rule, or practice direction. So just quickly on that one, when we talk about public documents, quite often clients are like, well, why do I need to disclose a copy of their website? Why do I need to disclose a copy of this particular directive that came out about these issues? If it's a public document, I shouldn't have to disclose it. It's not secret. That's because it's important that the other side appreciate what documents that you want to rely on. So you might be saying, we want to rely on the information on your website to make a point about some issue that you misled us on. So I need to disclose that. The other party are aware that we want to rely on that. They can make comment on that. They can prepare that that's going to be used against them. Once you've gone through that system, hopefully that's the end of it. But if one party finds that they don't have the information that they want, that wasn't initially disclosed, they're going to have to make a request to produce under 28.16. So this is where one party will describe in a formal document the documents that they're seeking or the category they're seeking. They're going to describe how those documents are relevant and material to the issues in the case. And they're going to state why they don't have it and why they think the other party do have it. Okay, and these rules are all based on the IBA guidelines on evidence, which is what's used in arbitration, and which the rules have recently been updated on to keep it in line with the most recent IBA rules made in 2010. And when you look at Part 28, it has in Schedule A a document to help you set out your request. It's what in arbitration is called a red phone schedule, and the DIFC courts have adopted that. And it's extremely helpful because it will set out in a table what you're seeking, why you're seeking it, why the other side you think have it, and another column which is empty, which will be for any objections. Because the next step is if the other party doesn't want to disclose that material, it will need to fill in that last column and file it with the court to say we're objecting to disclosing this material. And the rules tell you the grounds on which you can disclose. So you don't need to think too hard about the particular reasons for objecting. If you look at the list, if it fits one of those criteria, then that's what you need to put in there. So maybe it's been destroyed or lost. Maybe it's maybe you can test the fact that that information is irrelevant. Because if a document is not relevant, you don't even have to worry about confidentiality or anything else. If there's a compelling ground of technical or commercial confidentiality, and there's a few other grounds. So one party is objecting. That gets put in the table, then you're likely to have a hearing for the court to consider these issues and make their order, and that order is called a document production order, and that's under 2836. So that's your basic disclosure process. If you don't comply with that process, if you don't disclose a document that you're going to that you've been ordered to disclose, then not only are you going to be potentially in contempt of court and have a very unhappy judge, you're going to also perhaps open the gateway for the judge to make an adverse inference. Why are you not disclosing the material? It must be because it's adverse to your case. So quite often when I have clients that are resistant to making disclosure when they've been ordered to do so, it's usually the simplest way to bring them around is, even if you don't disclose this material in contravention of an order made against you, which was in itself is extremely serious and you wouldn't want to go there, but even if you did want to go there because it's so important to you, the court is going to make an adverse inference anyway. And it's probably going to be a lot worse than what's already been disclosed. So if you don't want to disclose it for those reasons, you probably want to think about whether you want to be part of this litigation. You don't want to be settling this case, because it's going to end up bad if you do not make that disclosure. The rules do address e-disclosure in a more direct fashion. My colleagues, I'm sure, here will describe in more detail some of the issues that you have with e-disclosure. But given the kind of material that you have, thousands of documents, metadata, and everything else, the rules actually help you along with how you can better manage e-disclosure. Which brings me on to my next key point, which is the timing for disclosure. Okay, so I've described what the basic process is, the standard disclosure process. The timing of disclosure formally is at the CMC stage. So after the pleadings have been done, you're going to have a case management conference, which is where the parties and the judge get together to describe and discuss what orders are needed for the proper preparation of the case up until trial. And if you look at the case management section in the RDC, you will see attached to it a schedule, which is the case information sheet, which is a series of questions which are completed by the parties and filed at the court before the CMC. And you will see that the first substantial question on that list is disclosure. What documents do you want? What documents are you going to disclose? What kind of volumes are we talking about? 20 volumes, just a few documents. That's the first thing. That's how important it is. You also find that the RDC, very early on in Part 28, makes it very explicit that you need to cooperate with the other party. Gone are the days where two parties in a common law system fought it out at arm's length. Now they're expected to and obligated to discuss these issues before they even get to the CMC. How much can they agree? Can they agree the keywords? Can they look into whether they can come to an arrangement on the scope of a particular disclosure request, so that the court does not have its time wasted with spurious requests and silly things which the parties, if they'd actually just spoken, could have resolved quite easily. There is now an ongoing obligation to disclose under RDC 2845, so parties need to be aware that just because they didn't find that document in the first instance, if 4 months down the line someone opens up a drawer and lo and behold, there's that document, they can't just shut that drawer again and forget it ever happened. They have to give that to their lawyer. The lawyer will need to disclose that and will need to be managed. But you have that obligation. If it's found out at trial that actually you had it, you didn't disclose it, you're going to be in that unfortunate situation I described earlier of potentially being in breach of court order. I only have 3 minutes left. So I've just gone through then some of the key aspects, and I just want to quickly raise 3 more advanced aspects of disclosure whilst I have your attention. The first one is pre-action production of documents. This is where, under the court rules, a party can go to the court before they've even filed the action and seek an order that another party disclose documents. Okay? And the idea there is that if both parties are going to be part of the litigation anyway, and if this kind of documentation is going to be part of the disclosure anyway, and if those documents are going to help you resolve the issues before you have to spend all the time and money of actually filing the claim, then let's have the order now, let's have those documents disclosed, and hopefully this case will get settled or resolve itself before everyone wastes a lot of time and money. But just be aware that if you make that application, the cost rules are reversed. Okay? I mean, even if the other party contests that application, they lose, they have an order of disclosure against them, their costs would generally be borne by the party making the application. And that is found in RDC 3865. It's often overlooked, but it's there, so just be aware. And it's been upheld by the Court of Appeal as well in the DIFC. Second one I want to raise is third-party disclosure. Okay, you're not restricted to seeking disclosure orders from the other party. If you know that a third party has disclosure material which will be helpful to you, you can make an application to the court, and in circumstances you can get that disclosure. Okay, that can be a very powerful tool in certain circumstances. You also have an unqualified right to inspect documents mentioned in the statement of case or witness statement. So what I say to people is be careful what you plead, because don't think that you can just make reference to various documents and think they'll never come back to you. Okay? If it's stated in your statement of claim that a certain document was filed, a certain document was found, even if you don't want to rely on that document, the fact that you've referenced it and made mention of it would allow the other party to say, I want to inspect that document. I don't have to show why, I just have a right to do it because you've mentioned it. I now have 58 seconds to go through some of the general points, which is why I left them to the end, because I wanted to get through some of the technical matters first. But the two major general points I want to get across is this. The first one is, although it's easy as a common law lawyer like myself to think that disclosure is a very important and conventional way of having a helpful litigation process, it's actually, for a lot of people, quite counterintuitive. And most clients will be quite shocked to find that they will have to disclose to another party confidential material. When the parties are getting together and making a contract and they're happy with each other, they would never think in a million years of saying to the other party, do you mind disclosing to me your personal emails, your confidential emails and within your team? They'll say that was quite outrageous. But when you have a dispute, all of a sudden that's on the table. And the party will say, oh no, I want to actually now see those documents you were negotiating. You had emails, that's relevant, let me see that. And most clients get pretty affronted by that. And it's the first time usually in the litigation process where they lose control. And before, when they were just quite happy to make any odd allegation, so that's telling me to shut up now. That's usually when they find actually they're not in control and they have a serious problem. Different jurisdictions have different approaches. And if I could just impose one more half minute on you, you will see quite often stated that there is a big difference between common law disclosure and civil law disclosure. And people will say to you, well, in common law we have all this disclosure I've just described to you, but in civil law we just don't have that, or you don't get it in the local courts. Okay, that is broadly correct, yes, but if you look into the history of disclosure, you will see that before 1854, the common law courts in England didn't have any power to make disclosure. It was not a common law concept. It was actually a civil law concept, which the common law courts took and then expanded upon. And if you look at the civil law, if you look at the UAE law, for example, the evidence law, you will see there are provisions there for disclosure. They're just not very well used and not widely used. And this is why this myth has been propagated, that actually it's a common law process and not a civil law process. But you do find that, in fact, it's historically the other way around. So thank you very much for your time, and I will now vacate my position here. Thank you.
Good evening. Thank you for your presence here. And let me start by introducing myself and why I'm here. I'm from Singapore, the Supreme Court of Singapore, and we have been looking into this area of electronic discovery for about 5 years now. And we've got a little bit of experience that we have built up over the last 5 years, which I hope that we will be able to share with you today. And hopefully, in doing so, you will be able to pick up on some of these experiences that we've had as you figure out your how to put in place a practice direction for e-discovery over here as well. I've got about 5 topics I want to talk about. The first one being that e-discovery really is about a change in culture and how a change in culture is necessary in order for us to accomplish what we want to do. I will then move on to talk a bit and share a bit about our experiences in making use of keyword searches, our experience in using discovery in stages or conducting discovery in stages in order to manage the scope of documents, scope of discovery and the volume of documents that have to be disclosed. I'll round off by talking a bit about why we favor this production of documents in our native formats. And I'll just close off by talking a bit about what we hope to see or what we expect to see in the next 5 years. So first about change in culture. Now essentially for e-discovery, when it first came on the scene in 2009, it was really a shot in the dark. It really shook the profession because in order for e-discovery to be carried out, what is absolutely necessary is for the courts and both counsel to sit down and to work through the practical issues, because e-discovery is no more than managing the process of producing documents in discovery and managing the scope of documents you have to produce and how we can make use of technology to control the cost that's associated with giving discovery and also to manage the scope of the volume of documents that have to be given out. So a lot of the experience in Singapore has been around this topic. around this area. And our practice directions actually was amended in 2012 to provide a checklist that will assist in this discussion, a discussion which has to take place between lawyers before they come to court and together with the courts as we manage the process of discovery. Now, in order for that to happen, counsel need to be familiar with the issues. They need to be familiar with the witnesses that they eventually intend to call, because that is also very key to limiting the scope of disclosure. The other thing that we also provide in our practice direction is a template, certain templates of e-discovery plans and protocols that parties can use as a basis for their discussions, as a basis for them to negotiate how they want to go about carrying out discovery. So really, it's really about a culture change, no longer combative or adversarial, but really a focus on collaboration to get through this stage. Now, I'll move on to talk about my second topic, which is our experience in the use of technology, in particular the use of search terms. That's often the technology that's associated with e-discovery, and often the thing that frightens most people away. They say, what's the point of having all these search terms in order to turn out huge volumes of documents, which we then need to have a huge army of associates and partners to go through? Isn't that costly? Well, our approach to the use of search terms has actually been quite the opposite. We've always encouraged the use of properly crafted search terms that will strike the right balance. We don't want search terms to literally get you the filing cabinets. That's not the point. The point is to make use of search terms to come out with a group, a set of search results that will be useful, a set of search results that will not take too long to review. And there are several ways of doing that. I won't go into the details, but one of the things that we've found, which is very useful, is having had counsel collaborate and discuss and agree on as many search terms as they can. What happens is when they come before the courts in a contested application for the use of search terms, we require that they run what we call a preliminary search, which is simply a search using those disputed search terms. But we do not require that they review the documents just yet, just come with the number. Let's see how many searches, how many results are thrown up by those disputed search terms. And our experience has been that just going through this step, it dramatically cuts down the areas for dispute, because the outliers immediately fall away and parties are able to then concentrate on how to craft their search terms. A second area of our experience in the use of search terms, I would not want to go into, because there are several cases that talks about how to pick search terms and what not to do. The summary of all that really is to pick search terms that are as pinpoint as possible, and to avoid words that are frequently used in common business writing, and one thing to avoid is, of course, legal concepts, like no one actually writes breach of contract in an email. I'll move on to talk a bit about the third area of our experience, and that's how we've used discovery in stages to control the volume of discovery. This is something that we picked up from the UK case of Goodale, and our experience has been very positive. The idea is this: instead of listing 20, 30, or 40 witnesses and then going through each and every one of them and searching through all the repositories that they are under their control, let's focus on the key witnesses that you would normally have called to the trial. That's the starting point. And our practice has been, our experience has been that if most of the time, 6 to 8 witnesses in the first stage is quite sufficient. We agree on the search terms, we run these searches against the repositories of these 6 to 8 witnesses, and in our experience, we haven't really had a case that requires a second stage where we expand beyond this initial set of 6 to 8 witnesses. Although in theory, stage discovery allows us to do so, but the practical experience is that actually 6 to 8 witnesses, more than sufficient. And the reason is fairly straightforward, because today, whenever we send emails, we copy about 20 other people on the email, and the same email is repeated in the repositories of the 20 individuals. We don't need to go through all 20 persons to find the same email. We just need to go through the key witnesses, and that's been our experience. I'll move on to talk a bit about the fourth point, which is our preference for native format production. I think if you go back to the history of e-discovery in the US, where it first started, there was a huge preference for production in TIFF or PDF format. When we released our practice directions in 2009, we actually picked native format production for two very simple reasons. One, we knew that the metadata that is stored in the native format is valuable evidence. And if we were to use native format production, the metadata is preserved and it is produced. And second, what we want to do really is to stop the inefficiency or to avoid the inefficiency of what we call a round trip, where you have electronic documents that are text searchable, you print it out, and then only to scan it back as PDF, and then you have to run an OCR process just so that you can get them text searchable again. What's the point? With modern technology, what we've tried to do is stick with native format production, make that the preferred format for production, and if that format happens to be text searchable, it will remain to be text searchable, and you get all the benefits of having text searchable file formats in the downstream portion, because discovery really is just one stage in your litigation process. It's intended to feed the subsequent stages, which is the preparation of your witness statements and the preparation of your witnesses for cross-examination at trial. So that's the reason why we prefer native format production. And we've got several cases that come down to say that. We've got one recent case where one party unilaterally decided to produce documents in PDF formats. The other party objected, came back to court, was given a rap on the knuckles to say you should have consulted each other before you took a unilateral decision. So go back, retender everything in native formats. But there was a bit of a cost-shifting order as well, because the party waited too long to protest. So he was also a bit blameworthy. Now, I'll close off by talking about two quick issues. What we foresee to be coming over the horizon in the next 5 years or so. I think discovery being us living in this increasingly global and increasingly small world, discovery issues cross-border discovery issues will crop up, and we've seen some of those already. We've got one case where it was necessary to compel disclosure of emails that were stored in the cloud. And I think that the experiences of the UK and the US in the cases that deal with cross-border discovery will probably come in handy, because we are probably going to see the day where we will need to have tangle with foreign blocking statutes and civil procedure conventions, and how to grapple with them as we require disclosure of documents that are stored in a foreign jurisdiction. Another area which I think that we will probably be seeing a lot is the increasing use of, some people call it the Americans call it predictive coding, some others call it technology-assisted review. That's a new way of using technology to assist in the document disclosure stage, and that's probably one of those new technologies that we expect to come to Singapore very soon, and we hope to be able to grapple with grapple with the challenges that this new technology will throw up. Well, that's all I have, and I hope that the experience that we've had in Singapore will be useful. Thank you.
Good afternoon, everyone. I'm a lawyer. I've been a lawyer for 30 years, and when I qualified as a lawyer in the 1980s, I used to dictate a list of documents, and in a typical dispute, I would be lucky or unlucky if there were maybe 1,000 or 2,000 documents. Since 2011, I've moved from being a partner in a major London law firm to working with Milnet, and I have witnessed over the last 8 years an explosion in the volume of data. And I think society and the legal profession in all countries are struggling with the same fundamental problem, which is how to control the volume of data. It's a problem which just didn't exist if you go back to the 1980s. In those days, people had to write things out in manuscript. If at best you would have an electric typewriter and you would have a piece of carbon paper and you would produce 2 copies of a document. Now, effectively, the cost of creation has gone down to nil. The Google statistic is, I think, in the last 24 months, more data has been created than in the previous 2,000 years. And as lawyers who practice litigation, the challenge is how do we cope with this tsunami of data? On a monthly basis at the moment at Milnet, we are receiving data which, if printed, would require more than 1 kilometer of shelf space. If you convert that into hours, review hours, it would take more than a century just to skim read the data that comes in each month to Milnet. You start to get the feel for the nature of the problem there. And electronic disclosure has the potential to make a huge difference if done correctly. Quite often when I'm talking to English lawyers, I give them the example that if they turned up at work with nothing else on their desk and they had 30 lever arch files of paper, how long would it take them to read the pages, to get them into rough order, maybe to make some notes, a basic index? And the optimistic lawyers say 4 days, the pessimists say 2 weeks, but it's that sort of length of time. If you go to any provider of electronic disclosure services with the same volume of material in electronic form, you will be charged something like £200, £300, £400 to do the same work. So done right, with native electronic files, this is .doc, Word documents, .xls, Excel spreadsheets, you can harness the power or harness the information in those files and use a computer to perform unimaginable work on huge volumes of material. The problem starts with the fact that unlike paper, electronic data is volatile. It's also amorphous. Where is it? If I were to ask you, how long have you individually, I'm assuming you all have mobile phones, how long have you individually held your mobile phones? I'm guessing the average is probably 12 months if we're lucky. So one of the first things I would say in terms of witnessing what is going on in England is lawyers are quite often slow off the mark when they're first instructed to actually identify what data there is there and whether or not action needs to be taken to preserve it. In the old days with a written file, with a hard copy file, a paper file, as long as someone doesn't actually shred it, as long as it isn't actually lost, the file will last quite happily for 100 years. Electronic data held on mobile phones, on laptops, on PCs is in a totally different category. It's volatile. It's dependent on the hardware that's running the disks not failing. It's dependent on people not losing their phones or their laptops on buses. It's also, I said amorphous, it isn't just in one location. Increasingly, we're seeing, with the cloud, we're seeing Hotmail accounts, Google Mail, iCloud, conventional servers, laptops, people with applications on their mobile phones. So in a sense, there's an issue of trying to hunt down where is the data, where's the relevant data. Beyond that, the fundamental challenge for the lawyers is actually to work out how to control the volume. And if I just give a very simple case, you could have a lawyer that turns up and says to us, we have a construction case, there were 30 people involved in the case, we would like you to image all their mobile phones, we would like you to image all their laptops, we would like you to image the email server, we would like you to image the document server. And we could spend a couple of weeks capturing just a vast amount of data, 20 or 30 kilometers of electronic file if you were to print it out, to try and give a feel for it. The more sophisticated approach is actually to say, who were the key people involved in this dispute? Normally, if there are a large number of people, there are 2 or 3 top dogs, 2 or 3 people that are in charge, and they will get copied in on the emails to everyone else. And it's actually having, if you like, the courage early on to say, we will focus on these individuals. We will consciously narrow the dispute down, or the scope of the disclosure exercise down, by identifying certain individuals. Now, to do that, and critically, you need to talk to the other parties. I think culturally, certainly in England, the litigation process has been adversarial. And if you like, there hasn't really been a historical tradition of the lawyers talking to each other in a collaborative way early on. But actually, as the volumes of data increases, it becomes imperative to try and agree date ranges, to narrow down the date range that you're looking at, to try and agree search terms, to try and actually agree if there's a way that actually people can further reduce the volume of material. Electronic data is incredibly valuable so long as it is captured correctly. I think you've probably heard reference a couple of times tonight to the reference to the metadata. It's the data inside the electronic files. So in an email, it's the to, it's the from, it's the subject line, it's the date, and it's the time. In a Word document, it's the author, the creation date, things like that. It is incredibly easy to destroy or damage that metadata. And if you do destroy or damage the metadata, the potential savings in costs fall away quite dramatically. One of the joys, I suppose, of working now and seeing different practices, good and bad, of law firms around the world is we see some law firms where literally they have printed out electronic documents and converted them to paper, and then they've scanned the bits of paper. And in some ways, I almost want to cry when that happens, because you have lost 90% of the value of the document. Yes, you can still read it as a human being. Your eyeball can still read the text. But all the lovely ability to actually work out when the document was created, who it was sent to, where it was located, searching the thing reliably has gone. So preserving the data in a way that doesn't actually mess up the underlying metadata is incredibly important. And again, it is a new skill that we as lawyers need to acquire. In the old days, you would just say to your client, please make sure that you preserve the paper file, and I'll come and collect the file at some point and I'll photocopy it. What needs to happen now is the client needs to be advised of the need to preserve the material, and that it needs to be collected in a way that actually preserves the metadata, preserves the integrity of the material that's been collected. Beyond that, the next issue, I think, probably is actually how do you actually find the relevant material? And I think the point I would make there is it depends utterly on a case-by-case basis. It requires the input of the judges to actually control the disclosure process. If you're dealing with a case where there is something simple has happened, there's been an explosion, or there's been a ship has sunk, it's generally very easy to home in on the relevant issues. It's very easy to home in on the event. And it's normally relatively easy to actually go back in time to the extent that you need to look and see what the involvement of the various parties was. There are other cases, if you have a complex construction case which involves delay, if you have a case involving fraud, where it becomes a lot more difficult. Because essentially the lawyers don't actually really know themselves what it is that they're looking for until they actually see it. And the one disastrous thing you can do in that situation is to start just blindly coming up with keywords with a view to finding the potentially responsive material. The problem with keywords is they can be very, very good. If you're looking for passport numbers, social security numbers, hospital numbers, email addresses, a keyword is actually a very effective tool at finding documents which contain that string of text. But if you're looking for documents relating to delay in a construction case, or if you're looking for documents relating to fraud, search terms are pretty useless. Now, the problem underlying this is that if, even allowing for the fact that you've reduced the number of people that you're going to try and collect the data from and you're going to look at, if you have 200,000 or 300,000 documents and they're sitting on a computer, we can run searches for you incredibly cheaply. In fact, we can run the search just as cheaply if you give us 3 million documents or 30 million documents. But when you get the documents that are responsive to the keywords back and you give them to a lawyer, suddenly all the benefits, the wonder of IT falls away, and you are dependent on the lawyer, the human eyeball, reviewing these documents at probably at best 100 documents an hour. And we regularly encounter cases where lawyers have come up with keywords such as delay or warranty. And in one sense, it's good. They've gone for a keyword which it will almost certainly capture absolutely everything that relates to the case. But the problem is it is also going to capture 500,000 documents which have got nothing to do with the case. And this leads me neatly on to proportionality. For disclosure to continue to exist as a concept, I believe proportionality will need to be brought in in a much more strong way than has been happening. Essentially, every 18 months, the volume of data is roughly doubling in a typical case. That's what we're seeing at the moment. At the moment, certainly in England, I think the lawyers and the judiciary are reluctant to deviate from the traditional approach of applying the rule of standard disclosure, all documents that relate to the case. The test is meant now to be all documents that relate to live issues in the case. But even now, my experience is a lot of cases, we have a lot of what I would call wallpaper documents. They're peripherally relevant. Yes, they relate to the matter generally, but they don't really relate to the live issue. I think I'll stop now and hand over to Richard. We've got a slight issue, which is we're both English lawyers, and we've got a demarcation dispute as to where I should stop and straying into legal territory. Thank you.
Chief Justice, Your Excellency, ladies and gentlemen, good evening. 3 principles inform the approach of the courts of England and Wales to disclosure of electronic documents. First, cooperation with other parties before the first CMC. Second, proportionality in terms of the scope of disclosure and the costs associated with such disclosure. Third, a reasonable search, not necessarily an exhaustive one. There's also an interesting developing aspect which relates to the duty to preserve documents. When does that duty kick in? There's also the interesting development which has been mentioned with storage on things like cloud computing, which gives rise to certain cross-border issues and jurisdiction. What I'd like to do first of all is to deal with context. And in dealing with context, might I first of all put myself in context. I have been in practice as a barrister in the courts of England and Wales for over 30 years. When I started in practice, there was no mobile phone, there was no internet, and we had the beginnings of the fax machine. Some of you might remember the very shiny rolls of paper which used to come out. Well, the world and the scope and context of my practice has changed substantially since the 1980s. Since 2000, most key contemporaneous commercial documents have been and are contained electronically by way of electronically stored information. Today in the United Kingdom, more than 90% of all communications are recorded in that form. Telephone records, texts, emails, bank records, and so on. Electronic documents are documents within the meaning of the British Civil Procedure Rules. The creation and retention of electronic documents has changed the way disclosure is managed in the courts of England and Wales. This is so in terms of the professional responsibilities of the lawyers and also in terms of the obligations placed on their clients who are parties to the litigation. The issues which arise in relation to the disclosure of electronic documents are different to those that arise in relation to paper documents. The reasons for these differences or difference will be readily apparent. and it centres on the huge volume of electronic documents which are created, or documents which are created and stored electronically, the ease of duplication of electronic documents, the lack of order in the storage quite often of electronic documents, the differing retention policies of the parties to a case, the existence of metadata, and the fact that electronic documents are more difficult to dispose of than paper documents. Electronic documents present, not only within the United Kingdom, but from what we've heard, Singapore, this jurisdiction, and internationally, fundamental challenges to litigation in terms of the massive volume of information potentially available. You've heard from John and his experience of it, and as he has indicated, it is something where the sheer volume is difficult for us to contemplate at times. Now, the techniques deployed for retrieval and the organization of such material, the tendency of much of the electronically stored documentation to be irrelevant to the issues in a case, and the proportionality of the disclosure exercise and costs involved are part of the challenges we who engage in litigation face. In the United Kingdom, or perhaps I should say England and Wales, because the Scots might differ on this. In England and Wales, the Civil Procedure Rules Practice Direction 31B was introduced, and it deals solely with disclosure of electronic documents. And what I will consider briefly is the approach of the courts of England and Wales to the disclosure of electronic documents before the CPR Practice Direction 31B was introduced in October 2010. We will then briefly look at that practice direction. And then finally, I will seek to look at about 3 cases to see whether there are any trends since the introduction of the practice direction that we might be able to discern. In view of the time, you might be relieved to know I'm not going to go into any of the cases in any depth. What I propose to do in terms of the pre-practice direction cases is simply to summarize them by way of these points. First, the parties should cooperate in terms of the use of keywords, and in the event that they are unable to agree, they should apply to the court for directions. That's the Digicel case, where over 1 million electronically stored documents were involved. And in that case, the parties had no communication at all as to how they might go about dealing with over 1 million documents, few of which, at the end of the day, proved to be relevant. And the court made it clear that was not acceptable, and what parties ought to do is to cooperate, and in the event that they can't agree on a methodology, to make an application to the court for directions. Second, it is no answer to a request for electronic disclosure to say no electronic search is necessary because it's already printed. That was the case of a bailer, or, even more excusably, that a party did not wish to carry out an electronic search. That was the case of Goodale, which involved the Ministry of Justice, who said, well, look, this is all going to take too much time and we just don't see why we should do it. We're going to have to spend a lot of resources, etc. court said, well, no, that's no answer. And what they did in Goodall was to have a staged disclosure. First of all, organized around key terms, key individuals identified, direction for disclosure limited in that way. Then the court said, well, let's see where we get to with that. It might meet the point generally. It means that the disclosure is proportionate and reasonable. If it's not enough, come back and the court may give further directions. Third, there was no duty to preserve documents before the commencement of proceedings. However, and this relied this is the case of Earls, and relied on some earlier case law. However, where there was clear evidence of deliberate spoliation in anticipation of litigation, a court would be able to draw adverse inferences in the litigation on the basis of the rule of evidence that everything is to be assumed against a destroyer of evidence. And I won't give you the Latin in it, as we are told not to speak in Latinisms anymore. Short of such evidence, the court could still visit its disapproval of defective disclosure by a cost order at the end of the case, because the court is empowered to have regard to the conduct of the parties, both before, during, and during the litigation. And ultimately, if a legal representative failed fundamentally to deal properly with disclosure, the court could visit its displeasure upon such solicitor by way of a wasted cost order. That was stated in the case of Heydrich, although in that case the Court of Appeal at the end of the day said it was not appropriate to make a wasted cost order. I'm going to move very quickly on to the Practice Direction 31. I hope you've got a copy of it in front of you. In the time available, all I propose to do is just to highlight certain matters. So what happened was in the early noughties between, say, 2007 and 2010, the High Court and Court of Appeal in England and Wales started to grapple with electronic disclosure. I have distilled some of those principles, and what happened in terms of the Practice Direction 31B is that the court took that body of case law, the approach of the judges, and built on it in terms of the practice direction. Also, there'd been a working party led by a High Court judge that had looked into this matter. And this is what we have. Purpose and scope of interpretation, if I can go to that first. Paragraph 1 refers to Rule 31.4, contains a broad definition of document. This extends to electronic documents. The purpose of the practice direction is to encourage and assist the parties to reach agreement in relation to the disclosure of electronic documents in a proportionate and cost-effective way. There we see a distillation of the earlier case law. If you go, please, to paragraph 5, subparagraph 3, and note the definition for electronic document, means any document held in electronic form, and then goes on to give examples of what it includes. Then, in terms of the general principles, paragraph 6, every time the disclosure of electronic documents is considered, the parties, and note, their legal representatives should bear in mind the following general principles. 1, efficient management in order to minimize costs. 2, technology. in order to ensure that the document management activities are undertaken efficiently and effectively. 3, disclosure given in a manner which gives effect to the overriding directive. And I'd like you to also note 5, that the disclosure of electronic documents which are of no relevance to the proceedings may place an excessive burden in time and cost. I'd like you to note paragraph 7, the preservation of documents. What we have for the first time, represented by this paragraph in the practice directive, is, in a sense, the development of the case law, stating as soon as litigation is contemplated, the parties' legal representatives must, not might, notify their clients of the need to preserve disclosable documents. The documents to be preserved include electronic documents which would otherwise be deleted in accordance with a document retention policy or otherwise deleted in the ordinary course of business. And that informs of one of the cases pre this practice direction coming into effect, where a firm of solicitors who are defendants in the proceedings said, well, look, we don't need to give electronic disclosure because we print off everything anyway, which is relevant. And also on top of that, there was a case involving a bank, the Hedrick case, where they said, look, we get rid of documents after a certain time, we have a retention policy, and so on and so forth. And that happens in the ordinary course of business. Well, practice direction makes it clear that's no longer good enough. You will have to, solicitors, lawyers, inform your clients, and your clients must then preserve the documents as soon as litigation is contemplated. And then we can see, in terms of cooperation, that there should be discussions between the parties before the first case management conference in relation to the use of technology and disclosure. And note paragraph 9, that the parties and their legal representatives must also, before the first case management conference, discuss the disclosure of electronic documents. And there is, you can see at subparagraph 4, there is the reference to the preservation of documents with a view to preventing such loss of documents before the trial. There's now an electronic questionnaire, which is paragraph 10, and paragraph 14 sets out what the parties must do before the first case management conference. And then at 17 to 19, what they must do where they're unable to reach an appropriate agreement in relation to the disclosure of electronic documents. The question of a reasonable search makes it clear that it must be done subject to the overriding objective, which includes dealing with the case in ways which are proportionate. The factors which ought to be borne in mind at paragraph 21 are set out. And note over the page at paragraph 25, the keyword and other automated searches. And the point is made in paragraph 26 that it will often be insufficient to use simple keyword searches or other automated methods of searching alone, and that the injudicious use of keyword searches and other automated searching techniques may result in failure actually to find the important documents, but also retrieve excessive quantities of irrelevant documents. And just a final note that the electronic documents questionnaire is set out in a schedule towards the back of that paper, of that practice direction. In view of the limitation of time, I think what I will do, I will not go through the detail of the cases since the practice direction came into force. I will mention the cases and then I will move to a conclusion and seek to extract certain approaches. There's the case of CPS Butler Limited, which is 2013, where an application was made seeking permission to search for certain electronic documents which had been taken during execution of a search order against the defendant. What the claimants wanted was permission for disclosure of the electronic documents to be conducted by their expert and not by the defendant. And the claimants proposed that their expert would search the images by keywords intended to identify relevant material. The High Court dismissed the application because such an order would deprive the defendant of the opportunity of considering whether or not they would make any disclosure, and that was and would amount to an excessively intrusive order, even if done on notice, because it was contrary to normal principles of justice and could only be done where there was a paramount need to prevent a denial of justice to the other party. Such a need, for instance, might arise where a party had had the opportunity to disclose, had failed to do so or refused to do so, and the court might in those circumstances take the view that it was consistent with the interests and principles of justice for the court to permit a party to send their own expert in to look at the material and to decide which of the matters ought to be disclosed by that other party. There is the case of Frost Capita Financial Managers Limited, where the High Court refused additional keywork searches to be carried out on the basis of proportionality. And that was a case in June of this year, and in July of this year, in the case of Ray Atrium Training Services, the Court of Appeal made the distinction between the obligation to make a reasonable search for documents and cooperating with the other side with regards to electronic disclosure. And in that case, it was found that the defendant liquidators had not carried out a reasonable search for their own documents, notwithstanding the fact they had entered into a perfectly acceptable agreement with the other side with regard to the disclosure of electronic documents. I'm now going to conclude, and taking the case law together with the practice direction, and that's the case law both before and after, and the practice direction 31B, it demonstrates the following approaches by the courts of England and Wales to the fundamental challenges posed by the disclosure of electronic documents. First, there's a duty on the parties to cooperate in the use of technology in the disclosure and management of electronic documents and the conduct of proceedings. Failure to cooperate is likely to be met by sanctions by the court. Second, cooperation in managing the disclosure of electronic documents does not absolve a party from complying with its duty to make a reasonable search for documents, including electronic documents. Third, there is no general duty to preserve documents before litigation is contemplated. However, as soon as litigation is contemplated, the parties' legal representatives must notify their clients of the need to preserve disclosable electronic documents, which that would otherwise be deleted in accordance with a document retention policy or indeed in the ordinary course of business. Fourth, if evidence is destroyed or not retained at any time prior to the contemplation of litigation, the court might still draw adverse inferences on the underlying issues in the case on the basis of the rule of evidence that everything is assumed against a destroyer of evidence. Fifth, keyword searching is one technique for managing the volume of electronic documents for the purposes of disclosure, but there are real limits to its effectiveness. The parties should consider supplementing keyword searches and other automated searches with additional techniques, such as individually reviewing certain documents, for instance, important documents generated by key personnel. Sixth, in terms of a reasonable search, parties must bear in mind the overriding objective at all times, which includes dealing with the case in ways which are proportionate. This might mean, in certain cases, such as the Goodale case, a staged disclosure, where disclosure might relate at first only to the email accounts of a limited group of individuals, with the option of further disclosure if the court agrees that it is necessary. The court, finally, will expect larger organizations, in particular, to manage their electronic information efficiently. And so, to conclude, looking forward, it may be that there might well be further shifts in the court's approach in relation to the non-retention of pre-litigation or pre-contemplation of litigation electronic documents. Given the increasing ease with which large quantities of electronic documents can be organized and stored, for instance, by cloud computing, large organizations may be putting themselves at risk of having adverse inferences drawn in litigation by the non-retention of electronic documents. And it would really lead to this, and these are my final words. Any practice which leads to the routine destruction or non-retention of documents, pre-contemplation of litigation, would probably need to be justified relative to the retention of other documents held by the organization. Thank you for your time.
Thanks to all the speakers for their contributions. I think we have time for a few questions, but let me just make one quick comment. I think people in Dubai and DIFC in particular ought to appreciate that our Part 28 is unique to DIFC. It is different from Part 31 of the White Book. And this is deliberately so. I can still remember the meeting where Michael Black came and explained why in our original version of the RDC, Part 28 was not going to be following English practice or American practice, but instead the IBA rules in the original version. Now, having said that, if you look at this, it actually bears very little resemblance to IBA rules because what is taken from the IBA rules in Part 28 is a test of relevancy. And the big difference between IBA rules and the general rules of discovery are that there is no obligation to help the other party. You do not start with that obligation. So it's a very limited and focused test for relevancy. Having said that, you look at the rest of Part 28, and then it picks up points which comes from Singapore, from Part 31, and so on. And so it is a melange, and you have to be careful about that. So the interesting, and of course, its arbitration origins is found in 28.27.1, which makes direct reference to what is called a Redfern schedule. Now, for those of you who don't practice international arbitration, you can justifiably put up your hand and ask, why are they using this term, which I don't understand? But it is something which every arbitration lawyer will know, and so ask your colleagues what it is about. So it does have its arbitration origins, but it is actually a blend of English traditional court procedures adapted for the electronic age and a pure arbitration approach. Now, who would like to kick off with some questions?
Chief Justice, I won't allow you to answer it because you have very succinctly identified what was my first point of submission. There seems, shall we say, little application or varying appropriately applied application of the practice direction of 13.1b, most particularly in relation to the preservation of documents. This is perhaps a discussion rather than a question I'd like to engage. Given the differences of the DIFC court's rules regarding not disclosure but indeed production of documents, and given the primary concern that nothing is disclosable or producible until there is an order for same, how then could it be expected that a party may be obliged to be obliged to, or more particularly the party's legal representatives, to notify their clients of the need to preserve disclosable documents? How can that have life, if you like, in the same context as it does in England? As soon as the litigation is contemplated, well, my first submission is nothing is disclosable until, as I've indicated, it's ordered to be disclosed. In that contemplation, by then, it may very well be that the ordinary document retention policy or usual deletion in the course of business may have done its deed, and it would be unrealistic to expect that legal representatives could persuade their clients to essentially retain the entire database in the vague allegation or in anticipation of there being in the future an application for specific production or specific disclosure, when the issues between the parties have not been identified and where there obtains no order of the court to regulate what disclosable material may obtain. So that wasn't a question at all, I apologise. It's rather a point of principle and a point of distinction where I think it would be dangerous for this court to simply adopt per se the practice direction that pertains in the courts of England and Wales.
Yeah, I just want to thanks, Vienna, for raising that, because that is an interesting point and one that I try and address when I do the more lengthy lecture, which is when we're dealing with disclosure in DIFC courts and we're dealing with the kind of clients that we have here, many of which are not used to disclosure and their obligations to disclosure. It's always, as a lawyer advising a client, when you do start feeling, well, actually, this is going to go to litigation, it's quite often recommended to write to the other side and say, FYI, we are looking to sue you or we're going to sue you. Please retain these documents. Please do not destroy these things, because even if they may be sophisticated, they may be aware of their obligations. And I think, Fiona, I think you're right. That I don't, from my recollection, believe that there is a provision in the RDC at present which says that you must do this, as it does in the practice direction, which we went through in some detail there. But I dare say the courts would take a very dim view of a party which, knowing there was going to be litigation, started destroying or just applying their document retention policy, notwithstanding the fact that it was obvious these documents were going to be disclosed in the future. Again, even when you look at the practice direction, you can see, well, if you're contemplating litigation, how do you know what's going to be disclosable? You don't know what the issues are. And as I said in my discussion, usually disclosure comes to a head at the CMC when you already had the major pleading, so you know what the issues are, and it's easy to see what is disclosable. And there will be cases where maybe that issue raised and maybe we need to retain that and maybe it doesn't and we just don't know. But I think normally if you think you're going to go and sue someone and you think they might well destroy that document, or it's going to take a good 6 months before you, or 3 months even, before you prepare your case, write them a letter and tell them, we expect to be requesting these documents, we want you to keep them. As I said before, you can always make the application pre-claim to say, well, we're going to sue you, we want the documents now rather than later. And if you can show there was a good reason for that, then that's going to be ordered. So, yeah, those are just my comments on that, so thank you.
Just add to that, today the Singapore delegation gave me a copy of a book of an international conference on electronic litigation, which was held in Singapore a couple of years back, which I remember that I attended. And I remember what one of the papers presented at that conference was about preservation of electronic evidence. And the speaker, Kavinder Bull of Singapore, explained to us that there was an emerging doctrine of a tactic in litigation called a legal hold. Now, the legal hold, if I recall correctly, is when one party is about to start litigation, it issues a notice to the other party and saying, we are starting litigation against you. You tell your client, do not destroy any document. And the argument then is, if there's no response to that, the person who issued the notice then runs into court and tries to get some kind of a preemptive, injunctive order. Now, I have to say, as I recall, and my colleagues from Singapore will correct me if I'm wrong, at the time that this paper was delivered, there was no Commonwealth case law that actively supported the doctrine. And I don't know whether Richard wants to tell us, because there's some reference to Hello case and so on. But the Americans had developed it. And there is a case here cited called Zubalaki against UBS, which is a 2004 federal decision in the US, where they explain the rationale and give support to the fact that the American courts do consider that counsel have an affirmative duty once they are put on notice of litigation to keep their clients informed and to advise them not to destroy any documents. Having said that, 2 days ago I was in Bern in a conference on arbitration, and one of the issues being debated was the new IBA guidelines on party representation. And these are supposed to lay down codes of conduct for lawyers in conducting international arbitrations. And one of the principles that was enunciated by the IBA guidelines was that lawyers should put their clients on notice not to destroy any documents as soon as they were aware of litigation. This aroused tremendous opposition in Switzerland. The Swiss Arbitration Association has circulated a document worldwide saying the Americans are imposing their standards on us. So this is a very controversial issue, but it's something that's worth thinking about and having more research on.
This issue was addressed in the case of Earls, where some reference to the American jurisprudence and the Australian jurisprudence was dealt with. And what His Honour Judge Simon Brown said in the Earls case is that the bank, that was Barclays Bank in that case, its legal department, the claimant, nor his solicitors took any steps, the obvious steps of preserving the contemporaneous phone and email records that would support or be adverse to their contentions, and holding them in anticipation of litigation between them, litigation hold, in inverted commas, as it is termed in the United States under their federal rules of evidence. And going on, the learned judge said that, however, in this jurisdiction, that's the English jurisdiction, as in Australia, there is no duty to preserve documents prior to the commencement of proceedings, and that was the British Australian Tobacco and Australian Services case. But it was suggested by one writer, Charles Hollander QC, in his book Documentary Evidence, 10th edition 2009, that there might be cases where it was appropriate to draw adverse inferences from a party's conduct before the commencement of proceedings, and that in the judge's judgment, that could only occur where there was some clear evidence of deliberate spoliation in anticipation of litigation before one could legitimately draw evidential adverse inferences in those circumstances. So there are 2 points really to bear in mind. First is, this is dealing with the drawing of adverse inferences in terms of the issues in the litigation itself. So on an issue of liability, for instance, if key evidence was spoliated, destroyed, got rid of prior to the case, a judge, based on that rule of evidence I've mentioned, could say that everything is to be assumed against the destroyer of evidence. But there is a second point to note, which deals with procedural matters set out in CPR Practice Direction 31B, which moves the position on from this case to saying where litigation is contemplated. And in terms of control in relation to that, you would run the risk in the jurisdiction of England and Wales, in view of that clear direction in the practice direction. If A, as a practitioner, you didn't so inform your clients, then you may well find yourself in difficulties. Solicitors are officers of the Supreme Court and ought to comply with it, and you could, in certain circumstances, if as a result important documentation went missing, there could be a wasted cost order visited on the solicitor. Secondly, so far as the solicitor's client is concerned, the destruction or the failure to retain documents once they knew, after they knew that litigation was contemplated, could have two effects on them. A, the court might take the view that this was a case where they should treat it as adverse on the evidential issues in the case, or it could take the view, if it didn't meet that threshold, that the conduct was such that there should be an adverse cost order against the party at the end of the case in any event.
I'll just ask Zikin to give us a wind-up from the Singapore perspective.
Yeah, on this issue of the duty to preserve evidence prior to the commencement of litigation, that actually, I'd always thought that it was an obligation that came about. Well, it's as closely associated with with discovery, but more importantly, in order to understand how this plays out, we really must place ourselves in the shoes of whether we are a plaintiff or a defendant. If you're a defendant, the time that you really know that there is going to be that you are going to be involved in litigation is probably when you actually, well, you know for sure when you are served with the writ, right? You probably have a very good chance if you are given a cease and desist letter, but it's not so clear. And I think that's from the perspective of a defendant, but from the perspective of a plaintiff, right? And this is where I think in the common law world, the obligations were not so clear, leading to the observation by the learned Simon Brown, Justice Simon Brown, QC, in the Earl Barclays Court decision, that on the plaintiff it is not so clear when this obligation attaches. Because in the US, it is very clear. The moment you contemplate commencing a suit, the obligation comes in. In the Commonwealth jurisdiction, not so clear. In Singapore, we had a case where the plaintiff commenced litigation. It had, by that time, destroyed all its evidence, had nothing left, right? And then it tried to get discovery from the defendant. And in that situation, the court struck out the case. And I think, which actually brings us to the focus, what really is the difference between this obligation to preserve? I think that in the experience of the US courts in the past 5 years or so have shown us this thing. It's really the consequence of the failure to preserve evidence that's the key. In the US, this doctrine of litigation hold and spoliation has led on to a line of cases that focused a lot on sanctions and punishments for the party that failed to disclose and kind of distracted everyone from the real battle. In the common law jurisdiction, we haven't rushed down that path, but there are concepts in the common law that talks about, hey, wait a minute, is it possible still to conduct litigation even without the evidence? Are we able to have a more measured approach? Can we, for example, draw adverse inferences against the party that failed to preserve the documents? Is it possible to get these evidence from other sources? Was the destruction deliberate, right? Was it intentional? There's a difference between deliberate destruction and intentional destruction. Was it deliberate destruction in the sense that it was intended to put the evidence out of the reach of the other party? Was that the reason why he destroyed it? In which case, then certain sanctions should come in. So I think what's going to happen in the next 4 to 5 years will be interesting to watch, because in the US, they probably want to scale back from this focus on sanctions and the failure to preserve. And for the common law, we probably will need to have a think about what are the kind of responses that we need to bring to bear to the consequence of this failure to preserve evidence.
Thank you. I'm afraid we have to call an end to this, partly because there's food and drink waiting somewhere else. So thanks to all of you for your attendance. I have some presentations to make, I think, thanks again and good evening.
Welcome to join a cocktail reception at the Capital Club on the 3rd floor, and many thanks to Milnet for supporting that. Thank you also to Omnis Global for the workshop they put on beforehand. Thank you to the chair, thank you to the speakers. A huge thank you to Haja for putting all of this together, and to Catherine also, who's our intern, who's assisted. And most of all, thank you all very much for coming along